In this video, I'm going to examine 150 problems with the conviction of Lucy Letby. I'm going to work through these as quickly as possible, but far more background detail is available in the 170 videos and well over 200 hours of video that I've recorded already. The images that will appear on this screen during the video also provide some of this background detail. So let's get started. 1. No one has ever seen Lucy Letby do anything wrong. This is uncontested and agreed by both the defence and prosecution. 2. Approximately 20 nurses who worked closely with Lucy Letby provided statements to the Thirlwell inquiry, and none of them had seen or suspected any wrongdoing. 3. The prosecution case is entirely hypothetical. It is therefore hugely reliant on the quality of evidence provided, which was extraordinarily poor. 4. There is no psychological consistency with a serial killer in Lucy Letby herself. There are no criminogenic factors. There is no indication of any breakdown in normal behaviour. 5. In common with this, Lucy Letby never referenced any murders anywhere. She never wrote about any murders. She never searched for anything related to murder. There is no indication of any macabre interests in anything related to her background. 6. There is no plausible motive for the supposed crimes of Lucy Letby, and no one has really even attempted to suggest one. 7. The shift chart that was a key item of evidence for the prosecution is riddled with problems and has now been discredited beyond retribution by multiple statisticians. 8. Professor Jane Hutton's statistical analysis of the Lucy Letby case, which had been commissioned by Cheshire Police, was cancelled due to orders from the Crown Prosecution Service. Professor Hutton is now a strident critic of the prosecution. 9. This issue with Professor Hutton was never disclosed to the defence team of Lucy Letby. 10. The definition of suspicious events used in compiling this shift chart remains far from clear. This hugely affects the way that it was constructed, leading to assertions from credentialed experts that it was essentially reverse engineered. 11. Lucy Letby was demonstrably not on duty for several collapses during the court case. 12. For several other collapses in the case, it was unfeasible that Lucy Letby could have carried out any malignant behaviour without detection, as she was accompanied by other nurses. 13. There is literally no evidence in many cases that Lucy Letby was even in the room when collapses occurred, even if she was on duty. 14. No context was ever given to the court or jury regarding spikes in big data being inevitable, which has been cited by many statisticians. 15. Child F was included in the original shift chart, which is an immediate problem with the chart, as Lucy Letby was not on shift for the allegations related to this infant. 16. Numerous assertions in the court case are entirely reliant on this shift chart being accurate. The prosecution relied on the assertion that Lucy Letby was always on duty throughout the court case, citing in it regard to Child A, Child B, Child C, Child D, Child E, Child G, Child H, Child K, Child L, Child M, Child N, Child O, Child P, and Child Q. Further inferences were made in relation to Child F. In fact, the only infant to which I haven't found specific reference to this in court is Child J, for which Lucy Letby was found not guilty. 17. The prosecution case significantly misrepresented the state of numerous infants involved in the court case. It is now universally agreed that many of these infants were very unwell, and it is known that none of them were stable. 18. One example of this is Child G, with this infant suffering from decreased lung capacity and chronic lung disease, hyaline membrane disease, bilateral pulmonary interstitial emphysema, a serious lung condition, hypoglycemia, gastroesophageal reflux, which refers to stomach acid flowing into the esophagus, thrombocytopenia, low blood platelet count, and blood gases indicating signs of sepsis. Dr. Xu Li described child G as an infant with a lot of chronic problems. 19. Child D was described by Dewi Evans, the primary prosecution witness in court, as being extremely well. This is an infant suffering with pneumonia, other infection, respiratory distress, who had been subjected to very poor care from the hospital and was sadly, inevitably doomed to pass away. 20. When challenged by Dr. Xu Li, Dewi Evans claimed that he had cited a delay in antibiotics as an example of poor care. Examination of the court transcript indicates that this is untrue. 21. This was the only example that Evans was able to give of poor care at the hospital, compared to the countless problems cited by a panel of neonatal experts, and even this one example is untrue. 22. Evans in fact stated in court that the care for child D was exemplary, even though in his initial notes he had specifically noted poor care over both the 21st and 22nd of June. 23. The case of child D is indeed emblematic of the entire court case. Lucy Letby is serving a life sentence for the murder of child D, despite not being present for the initial collapses, not being the designated nurse, not having been witnessed doing anything untoward or suspicious, and the fact that the prosecution case was entirely hypothetical, and it is agreed by all parties contradicting the prosecution case that the medical court evidence used in court is highly dubious, and that other more prosaic and obvious explanations for the tragic passing of child D, such as infection, were bizarrely completely ignored. 24. Numerous infants showed signs of infection, and this was all discounted by lead prosecution witness Dr. Dewi Evans. Evans never cited a single instance of infection as being significant. 25. This is despite the fact that literally the majority of infants in the trial were suffering with sepsis. All of this was discounted by Dr. Evans. 26. The deadly bacteria Pseudomonas aeruginosa was present on the neonatal unit. There is an intrinsic relationship between Pseudomonas and sepsis, which is well established. It should be emphasised that sepsis was practically endemic on the neonatal unit. 27. Another pathogen, Stenotrophomonas multifilia, was also detected on the unit. Contrary to claims that have been made, this was not ruled out by testing, as will be discussed later in the video. 28. The claims of Dr. Dewi Evans with regard to child G that the infant was overfed with milk are entirely laughable and not even taken seriously by anyone. 29. Child E was very clearly suffering with a massive gastrointestinal bleed, and the science used in court in relation to this child can reasonably be described as spurious and without any merit whatsoever. 30. Child C was suffering with a very obvious bowel obstruction, easily recognisable by any neonatal practitioner. 31. The vulnerability of twins and triplets was never adequately explained during the court case, nor was the disproportionately large number of multiple births in the court case, which is hugely significant. 32. There was virtually no maternity or obstetric information used in the court case. This is critical because there is an enormously important relationship between obstetrics and neonatology. 33. Indeed, we know from leaked police documents that Dewi Evans advised Cheshire Police that no maternity input was needed. 34. In fact, Dewi Evans hand-waved the need for any experts other than himself. This is despite the fact that Cheshire Police had been advised by the National Crime Agency that they should have multiple experts as part of the work that was ultimately conducted solely by Dr. Dewi Evans. (35) In the prosecution case, prosecuting barrister Nick Johnson made several extraordinary assertions regarding Lucy Letby supposedly systematically attacking twins and triplets, attempting to somehow tie them together emotionally, whereas the vulnerability of twins and triplets were never properly discussed. 36. The downgrading of the unit, which continues to the present day at the Council of Chester, was also never properly contextualised during the court process. 37. In fact, Dr. Stephen Breary commented that practices were going from good to better. The fact that we were working on a very good unit that normally had very good results, this all became exceptional, Dr. Breary explained in court. 38. Other issues with the Counter-Chichester neonatal unit, which was essentially condemned and closed down, were barely discussed during the court case. 39. Legal representative Corinne Slingo had told numerous key personnel from the Counter-Chichester in July 2016 that there is a likelihood that having changed the admissions criteria to remove the highest risk of sub-32-week neonates, that the mortality rate will drop significantly in any event. The court, naturally enough, never heard this. 40. Numerous odd claims were made regarding resuscitation, including the assertion that it is somehow straightforward. This is too complex to discuss at length in this video, but this is essentially a meritless claim. 41. Dewi Evans later informed Raj Persaud that getting a baby to start breathing again is quite straightforward, and that babies died in Chester despite what he considered to be outstanding efforts to resuscitate them. Conversely, Professor Colin Morley, an actual neonatologist, commented that the resuscitation of child C was just one example of suboptimal practice on the unit. There will be more discussion of this in my forthcoming book. 42. Claims were made in court and later repeated by police that neonatal collapses are always expected. This is a stupendously ridiculous assertion. 43. However, it can be argued that the collapse of some of these infants was indeed somewhat expected due to a combination of clinical signs, inattention, and poor treatment. Dewi Evans in particular failed to communicate these factors to the court and the jury. 44. Dewi Evans commented in court that most concerning was that the infants failed to respond to resuscitation, but in fact there are very good reasons for this. Dr. Evans either failed to notice or understand them, refused to cite them for some reason, or both. 45. In accordance with this, when writing to Dr. Jane Horden, a pathologist and neonatologist, Medical Director Ian Harvey observed that noting a failure to respond to resuscitation is always going to be very subjective. 46. There were multiple failures across several infants with breathing support and intubations. One of these was even cited by Dr. Jane Horden during her appearance at the Thirlwell inquiry. 47. Neonatologists that I have spoken with have criticised intubation practice on the unit, which is likely to have been significant in the clinical signs of several infants included in the indictment. 48. As mentioned, a very obvious bowel obstruction was ignored in the case of child C. However, child E and child J were among other infants who suffered with undiagnosed bowel issues, which also went largely undiscussed in the court case and which were completely overlooked by the peerless Dr. Dewi Evans. 49. Incorrect evidence was given by Professor Sally Kinsey with regard to child A and child B. Kinsey made erroneous statements regarding antiphospholipid syndrome in court, which contradicts clear guidance from the British Society for Haematology. 50. There were no genetic studies done for any of the infants in the case, yet thousands of potential genetic conditions could have contributed to health outcomes on the unit. 51. Child A couldn't have a long line pulled back because qualified staff were busy with another child. Several neonatal practitioners have described this to me as a very serious issue, but it was downplayed by medical experts in court. 52. Very clear signs of the serious intestinal disease, necrotizing enterocolitis, were discounted in numerous infants in the court case. 53. In the case of child J, Dr. Stephen Breary told the Thirlwell inquiry in a written statement that electrolyte disturbance might have caused a seizure. Other possible causes included sepsis or a collection of pus in the bowel. In court, Breary had commented that, "I do know hypoxia causes seizures, so that would be possibly the most likely cause." There remains the question of why child J was hypoxic when 2 or 3 weeks beforehand she had been breathing, breathing normally in air, and there was no suggestion of infection. It is not entirely clear how Dr. Bray's opinion changed so much in the intervening period. 54. A subcapsular hematoma cited by two pathologists in the case of child O, and also the panel of neonatal experts assembled by Dr. Shu Li, was bizarrely overturned in court by Dr. Dewi Evans. 55. Dr. Andreas Marnarides made a bold assertion about injuries suffered by child O being akin to those that one would suffer in a road traffic accident. It is notable that Marnarides conceded to relying on the notes and reports of Dr. Dewi Evans, and the assertion made by Marnarides has since been criticised by other pathologists. 56. Dr. Marnarides changed his mind in court, having seen the so-called medical opinion of Dr. Dewi Evans. 57. Dr. Dewi Evans changed his opinion and introduced entirely new diagnoses into the case during the trial, perhaps most extraordinarily in the case of child C. 58. But then Dr. Dewi Evans changed his opinion again after the trial, abandoning the opinion on child C that he'd introduced during the court case. Many suspect this is because the splinting of the diaphragm theory had been widely ridiculed by neonatologists. 59. It should be noted that Dr. Evans wrote to Channel 5 indicating in what can be reasonably described as a highly patronising letter that he was abandoning diagnoses that he'd used during the court case. 60. The Court of Appeal verdict is now contradicted by these changed theories, although that hasn't prevented Dr. Evans from explicitly praising the Court of Appeal more than once, even after he wrote to Channel 5. 61. Dewi Evans wrote an extraordinary letter to several newspapers in which he claimed that the police and prosecution had mixed up the dates for child C in court. The court transcripts for this infant reveal that Evans never did or said any such thing, and it's hard to characterise this as anything else other than an outright lie. 62. Dr. Evans also shifted around incidents during the trial after he had filed his final reports, ostensibly because Lucy Letby was not on duty when the original collapses were cited. 63. The peer review process conducted by Dr. Sandy Bohin, and which involved Dr. Dewi Evans, passing his conclusion reports to Dr. Bohin, a really obviously prejudicing factor that essentially renders the whole process worthless. 64. Coincidentally, Dr. Bohin agreed with absolutely everything that Dr. Evans said and barely contradicted him whatsoever during the court case. 65. The so-called peer review also did not include the aforementioned cases that were changed during and after the court case by Dr. Evans. These were never peer reviewed. 66. In fact, nothing in this case was blind. Dr. Evans walked into a police station in Cheshire and immediately claimed that he was certain that inflicted harm had taken place. This somewhat contrasts with the views of now 31 world-class experts who spent months diligently poring over case notes and never found any evidence of inflicted harm. 67. At various points, Dr. Evans has claimed to have used a differential diagnosis and a diagnosis of exclusion, but the methodology involved in the efforts of Dr. Evans comes nowhere near meeting this claim, not least because he only ever considered methods of murder. 68. In fact, the methodology of Dr. Evans is so specious that there are no diagnoses in the Lucy Letby court case, merely theories and hypotheses. In this video, when I describe the work of Dr. Evans' diagnoses, I am being unduly generous. 69. Indeed, we have now seen that none of the original diagnoses of Dr. Evans match those that were ultimately used in the court case. We know this from documents that have been leaked from the Cheshire Police investigation. 70. Furthermore, Dr. Evans initially treated several infants as suspicious, which were then later withdrawn from the court case. 71. In these initial notes, we can see Evans floating numerous potential methods of malfeasance. There is no way this can be described as an objective medical investigation. 72. Dr. Evans randomly made reference to a noxious substance in court, despite the fact that this had nothing to do with the allegations and he had already ruled this out of the court case. For some reason, he still referenced a noxious substance, even though it doesn't feature in any of his so-called diagnoses. 73. Dr. Evans had initially concluded that child C was at great risk of unexpected collapse, although it's not entirely clear how an infant can be at great risk of collapse, but the collapse is also unexpected. He then turned this around in later reports and completely changed his opinion. 74. In order to make child C stick, it was necessary to not only change days, but completely remove one incident from the court case. 75. We now know that Evans also initially looked at a completely different collapse for child O, but was then steered to the correct collapse when Lucy Letby was on duty by the utterly incompetent Cheshire Police. 76. In fact, there are multiple examples of Cheshire Police steering Dewi Evans towards the hypothesis of Lucy Letby being guilty, which is the only possibility that Cheshire Police ever investigated. 77. Cheshire Police also divulged information to Dewi Evans that they certainly should not have shared with him, according to the opinions of experts. 78. In the case of child C, a critical X-ray was taken at least one day before the infant child C died and prior to Lucy Letby having had any contact with the infant. Nonetheless, this was still cited as evidence during the court case. 79. Dr. Evans has made several claims that he wasn't aware of Lucy Letby's name during his investigation. The first thing that can be said about this is that Evans knew Lucy's name from 2018 at the latest because she was arrested at this time. Dr. Evans made countless amendments and submitted at least 25 reports after learning of Lucy Letby's name. Coincidentally, he then shifted cases, incidents and collapses all over the place, but always concluded that Lucy Letby was guilty. 80. Furthermore, Lucy Letby's name was all over documents that Dr. Evans saw in 2017. He conceded this to journalist John Sweeney. 81. By this time, Dr. Stephen Breary and Dr. Ravi Jairam had made it crystal clear to police in a meeting held on the 15th of May 2017 that they suspected a nurse, and even made it extremely easy for the police to identify that this nurse was Lucy Letby. 82. We now have documents which strongly indicate that Dewi Evans knew his job was to target a nurse and he was aware that a nurse was a suspect. 83. The cross-examination of Dr. Evans was a total train wreck. His performance in court was nothing short of an embarrassment. 84. In the case of child E, Dr. Evans originally suggested that Lucy Letby thrust a nasogastric tube down the throat of the infant. He later changed the object when he realised there was no nasogastric tube available. 85. Dr. Sandy Bohin cited the importance of a noise that she never heard directly based on a statement from parents that she never corroborated in what can only be described as a fairly extraordinary piece of testimony. Bohin still cited this as being central to the collapse of child N. 86. Dr. Dewi Evans used a 1989 paper authored by Lee and Tanswell as the sole diagnostic source for his air injection theory. Dr. Shu Lee, co-author of the Lee and Tanswell paper, has singularly rejected the theories of Dr. Evans and the way that his paper was used during the court case. 87. Dr. Lee has since headed a panel of neonatal experts which has similarly rejected the hypothesis that there were any murders on the Countess of Chester neonatal unit. 88. It is important to emphasise that this theory was central to the entire court case and that Dr. Shuley is also one of the most highly regarded neonatologists in Canada. Conversely, Dr. Evans never even qualified to be a neonatologist and hasn't set foot in a hospital for nearly 20 years at this point. 89. In fact, by now, no one really takes the theories of Dr. Evans even remotely seriously, which is important as they were central to the entire prosecution case. The more we learn about Dr. Evans, the more absurd and embarrassing he becomes. 90. Dr. Evans has made specious claims regarding having used 18 papers in court, but this was contradicted both by Evans himself in court and the Court of Appeal verdict, which Dr. Evans has praised more than once. 91. The logistics regarding air injection are highly doubtful, according to numerous doctors and nurses. 92. The potential accidental presence of air was never accounted for by Dr. Evans. It is quite obvious that air can be present in infants inadvertently. 93. Indeed, all of the papers that Dr. Evans cited were indeed related to the accidental presence of air. 94. During court proceedings, Professor Owen Arthurs gave evidence regarding a study which indicated that air is inadvertently present in approximately 40% of infants and always accidentally. 95. According to his own words, Dr. Evans diagnosed air embolism based on the sudden collapse of infants and the failure to respond to resuscitation. There is no known universe in which this is a valid diagnosis. It is entirely laughable. 96. We also know this is untrue now because of leaked police documents. 97. This means that Dr. Evans diagnosed air embolism before having any meaningful diagnostic criteria, because those cited would be consistent with literally dozens of conditions. This statement alone essentially completely invalidates everything that Dr. Evans presented with regard to this so-called diagnosis. 98. There are no published papers related to the mechanism of deliberate air embolism alleged in court, and both Dr. Evans and Dr. Bohin conceded that they had never encountered it before. 99. The literature cited in court was incredibly weak, related to deep-sea divers and animals, and even prosecution witness Professor Sally Kinsey conceded this during the court case. 100. Dr. Evans invented the highly precise and technical term a dollop of air during the court case. 101. Evidence presented regarding rashes was categorically incorrect. These were passed from one case to another, even though the rashes were notably different. 102. The evidence related to discoloration in the court case was simply wrong and has been refuted by Dr. Xu Li. 103. The Li and Tanswell paper did not describe the features of air embolism described in court. Indeed, the Li and Tanswell paper addresses pulmonary vascular air embolism, not venous air embolism. 104. The mottling and skin discoloration that were cited as being important in court is associated with numerous other conditions. Indeed, one doctor told me that anybody who is undergoing a circulatory collapse will become mottled. 105. Pathologist Dr. Jane Horden told the Thirlwell Inquiry that she was surprised that Ian Harvey had asked the neonatologist about mottling, because it is such a common finding in babies that unwell, and we were sadly talking about babies who were unwell. Embolism is something that would not have crossed my mind at all at that stage. When thinking about mottling, I would be thinking of common causes of mottling in the skin. 106. Discoloration seen in air embolism is very fleeting, which does not fit the timeline required in multiple infants during the court case. 107. The paper by Lee and Tanswell also references an earlier study, Post-mortem gas accumulation in premature infants, published in 1974. What this study demonstrates is that if X-rays of a baby are not taken within 25 minutes of death, the build-up of air or gas in the body is completely irrelevant because it's nothing to do with the situation when the baby died. 108. Dr. Evans never accounted for hyaline membranes, which were referenced by the panel of international experts with regard to child B. 109. Multiple neonatologists have since spoken publicly of their borderline contempt for the theories of Dr. Evans. 110. Inadequate insulin testing was done from the very start because immunoassays used to indirectly measure insulin that was used in the court case are prone to numerous inaccuracies and cross-contaminations. 111. An immunoassay is simply a screening test similar to a COVID test. There is no way that one immunoassay test should be used as the sole basis for deciding whether or not someone receives a life sentence. 112. The United Kingdom and Ireland Association of Forensic Toxicologists define immunoassays as a screening method and clearly state that they need to be followed up by confirmatory testing. 113. This is quite evident from the laboratory guidelines of the organisation, which state that presumptive screening tests such as immunoassay must be appropriate and validated for the type of biological specimens being analysed. With regards to immunoassay used on whole blood, they must be appropriately validated for that purpose, especially if using post-mortem blood. 114. Immunoassay does not directly measure insulin. It uses antibodies to bind to a substance that normally would bind insulin with high affinity, but can also bind other substances, hence the fact that it's presumptive. 115. Only mass spectrometry will distinguish exogenous insulin from endogenous insulin because some of the analogues only differ by a single amino acid. It's very easy to get false results, not just because the test can give false positive results, but also because there are errors, heterogenic errors, pharmaceutical errors, the wrong bag being delivered to the wrong baby, and many others. 116. It is an essential requirement, according to published standards, to undertake confirmatory testing of the immunoassay result using a different, more specific methodology. One which is often used and considered the gold standard is liquid chromatography mass spectrometry. 117. The insulin readings at a laboratory that tested immunoassays varied by nearly 800%. 118. Anyone can search for problems with immunoassays on Google Scholar. You will find hundreds of articles. 119. Both Child F and Child L, the two infants that Lucy Letby was convicted of poisoning, survived. Hence, there was no particular concern at the Countess of Chester at the time and no attempt to conduct critical follow-up testing. 120. The prosecution case relies on feeding bags being spiked. There is no proof of this. It is purely hypothetical. The hospital could have retained the feeding bags, and this would probably have exonerated Lucy Letby, but they did not. 121. Lucy Letby was not on duty for instances when feeding bags were hung out and when the supposed poisonings therefore occurred. 122. Without going into this in great detail, Lucy Letby would have needed to guess which bags were going to be hung out. The odds are simply against this, and it doesn't make any sense as a method of murder. 123. Feeding bags were chosen from the stock cupboard, not the pharmacy. Again, it would simply be impossible to anticipate this. 124. There were further logistical issues in the prosecution case which required a sticky insulin theory to be invented in order to explain these issues away. To say the least, this sticky insulin theory is contrived, inconsistent with measurements taken on the unit, and another highly dubious part of this overall logistically implausible hypothesis. 125. In relation to this, the expert who proposed this sticky insulin theory, Professor Peter Hindmarsh, was under investigation at the time of the court case. This was never revealed to the jury. Hindmarsh was later deregistered from the General Medical Council. 126. There are serious question marks regarding whether the method of poisoning and the specifics related to it indicated in court were pharmacologically possible. 127. Lucy was told insulin poisoning had definitely occurred and asked to accept this during the court case. This was an underhand tactic that had been used against her by the prosecution. Lucy Letby is not qualified to comment on this matter, and the prosecution were fully aware of this, as were Cheshire Police. 128. The jury heard very little regarding any doubts with insulin. They were in fact told that it was a definite poisoning and that all other cases would be dragged along by this assumption. 129. Dr. Evans told the court that there is only one explanation for what he described as astonishing blood readings. Child F had received insulin from some outside source. One might imagine that Dr. Evans actually knew what he was talking about, but he later told Dr. Philip Hammond of Private Eye that he didn't even know that there was more than one way of measuring insulin until he read comments from Professor Alan Wayne Jones. 130. Assertions regarding C-peptide made in court are now known to be demonstrably incorrect. Biological evidence and stringent study from literally the world's leading experts in studying is now readily available, and it indicates that the ranges asserted in court are simply plain wrong. One of these experts, Professor Jeff Chase alone, has over 250 published papers solely on insulin. He also has over 1,700 papers that are either published in his name or in which his work has been cited, and many of these are insulin related as well. 131. Child F was hypoglycemic with sepsis, which is far more relevant to the condition of the infant than some supposed hypothetical poisoning. 132. Blood sugar rising and falling as presented in the court case is consistent with naturally occurring hypoglycemia. 133. Errors were made with IV lines and the injection of boluses, which impacted on the care and well-being of child F. 134. The court was misled by Dr. Anna Milan, who, among several inaccurate statements, asserted that the only way you can get a pattern like this is if insulin has been given to a patient, which is a frankly astonishing assertion. 134. Dr. Gwen Walk, for some reason best known to herself, contradicted her own academic published work with Professor Vincent Marks during the court case. The defence could literally have obtained her academic paper, read it out in front of her, and destroyed her as a witness, but failed to do so. 136. The requirement for cases to be sent to Guildford for issues related to exogenous insulin was known about at the time, but ignored. This was flagged up by the laboratory who tested samples from the Countess of Chester at the time, and was also referenced by Sarah Davies at the Thirlwell inquiry, but this was never conducted. 137. Despite this, the court heard literally completely untrue testimony related to this. The aforementioned Dr. Anna Milan told the court that Guildford would have been deciding the type of exogenous insulin rather than whether exogenous insulin had been used, which is simply utterly incorrect. 138. Glucose levels of the infants were not measured at the time by the Countess of Chester Hospital. 139. Research indicates that the presence of antibodies, including insulin autoantibodies, can interfere with the immunoassay result and cause falsely high insulin results. This is a known problem with immunoassays. 140. There was a third insulin case with similar readings in which an infant was shown to be suffering with hyperinsulinism. The court never even heard about this infant. 141. In fact, this third case was hidden from the jury because it torpedoes the whole prosecution case. It was even rapidly removed from the Thirlwell inquiry website. 142. It should also be mentioned that the third insulin case was yet another infant with sepsis. 143. At the time that child F and child L were present on the neonatal unit, glucose readings of 999 were made, which is almost certainly a major error. This is just one indication that the testing and measuring of the baby's circumstances was erroneous. 144. From a practical perspective, Lucy Letby was a terrible poisoner because if she had spiked these feeding bags with insulin, the antidote of glucose was already present, meaning that the poisoning would almost inevitably be successful, which indeed it was. This is basic chemistry that virtually anyone with any awareness or intelligence knows to be the case, let alone a neonatal nurse. 145. Why would Lucy Letby use insulin when she had already supposedly been successful with air? She then supposedly failed to kill child F, returned to using air again, threw milk into the mix, and then attempted insulin again with child L, which failed again, and then moved on to further murder methods once more, introducing even new mechanisms. This can only be viewed as utter nonsense. 146. The court case relies on going back several years and re-examining figures in a haphazard way when it is clear that there was no concern about poisoning at the time, when both infants survived, and when there is a pattern of naturally occurring conditions that are commonly associated with premature and young infants. 147. Professor Matthew Yoll is just one person to point out that Olympic athletes and other sports people receive better testing and more protection than occurred in the court case of Lucy Letby. 148. The Forensic Science Regulator Code came into effect in 2023. This provides improved guidance for the use of forensic science in court cases. Unfortunately, this was too late to help Lucy Letby. 149. Hypoglycemia is simply far more likely for child F, and neonatologist Dr. Svelena Dimitrova, who has seen the clinical notes, has cited this as actually being quite obvious. 150. The closing statement of Nick Johnson on the insulin cases uses a litany of nonsense arguments. The bottom line is that the logistics of these cases makes no sense, and the science is also extremely poor, to be generous. In summary, at the end of this video, it can be concluded that the prosecution case against Lucy Letby was entirely hypothetical, methodologically weak, and dependent on junk statistics and medically dubious interpretations. There is no direct witnessed act of wrongdoing. The statistical and investigative scaffolding that linked incidents to the accused was fatally flawed, and many alternative and far more plausible clinical explanations for the collapses of infants were ignored. The central shift chart used to tie events to the accused is deeply unreliable, reverse-engineered, and completely discredited by statisticians. This immediately undermines many courtroom assertions and inferences. Emblematic of the failings of Cheshire Police to dispassionately investigate the situation was that an independent statistical review by Professor Jane Hutton, commissioned by the authorities, was mysteriously terminated. Since then, Professor Hutton has become a vocal critic of the statistics used in the case, and indeed the prosecution and conviction as a whole. The chief prosecution witness, Dr. Dewi Evans, has presided over what is an utter debacle, changing diagnoses, shifting infants in and out of the court case, misinterpreting both anecdotal evidence and scientific papers, using fringe theories for which there is no evidential support, and ultimately seeking malfeasance at all costs. It is hardly surprising that there is now an enormous amount of credentialed opposition to his work, and zero support. Many infants in the trial were medically unstable, septic, suffering with other infections or other recognised neonatal conditions such as chronic lung disease, bowel obstruction, necrotizing enterocolitis, gastrointestinal bleeding, and so forth. Common causes, especially infection and unit-level failures, were entirely discounted by prosecution witnesses, particularly Dr. Dewi Evans and Dr. Sandy Bohin. The peer review conducted by Bohin was also of derisory standard. Laboratory and forensic issues were manifold and multiple. Insulin testing relied on immunoassays, no more than screening tests, but no consistent confirmatory mass spectrometry work was performed. Immunoassays frequently give false or misleading results in complex neonatal samples. The feeding bag spiking and sticky insulin logistical theories are implausible and pharmacologically dubious. The alleged methods utilised by Lucy Letby were also far-fetched and not based on any meaningful measurements, as no feeding bags were retained and nothing was directly tested. The Countess of Chester Hospital neonatal unit was suffering with multiple systemic problems that were insufficiently explored in court, including endemic sepsis and procedural lapses. All of these issues were entirely excluded from the work of Dr. Dewi Evans, who we now know from leaked police documents deliberately avoided them in the first place, while acting as a relentless cheerleader for the calibre of the neonatal unit in court. The prosecution's presentation relied on emotive and deliberately misleading arguments and language that were designed to manipulate the jury. The conviction of Lucy Letby was built on discredited statistics, deceitful prosecution tactics, and desultory medical evidence, while ignoring very obvious clinical explanations for what occurred on the unit. The more that one learns about this case, the more surreal and despicable the court process becomes. Now, you might think that's a pretty hefty collection of issues with this court case, but this is only just the beginning. This is merely the first part of this video series, because 150 more problems with the conviction of Lucy Letby will be coming soon. If you have enjoyed watching this video, please consider subscribing to the channel. I'm enormously grateful for the support that I have received. We are now approaching 7,000 subscribers. I have recorded over 170 videos for the channel, easily over 200 hours of video, and have conducted nearly 40 interviews. This is just the beginning of my work on YouTube. There will be much more to come.